nga bwe bulambikiddwa mu ssemateeka. Etteeka twalireeta wano nga liva mu cabinet, naye engeri gye mmanyi engeri amateeka gye gakolebwamu byaweerezebwa mu bukiiko obubiri ak'amateeka n'aka defense ne internal affairs. Ne tujja wano ne tulyanjula, then abantu ne batandika okuleeta endowooza zaabwe ez'enjawulo nga mwe mulimu n'abo abaali naddala ebintu ebikulu bye baali boogerako ebyali nga bireeta concern byali ku definition ya omugwira ne agent w'omugwira, kubanga mu kuwandiiko kwasooka Munnayuganda ali ebweru yali mu ttuluba ery'abagwira. So ekyo nga kirina implications naffe twakiraba nti one kiringa ekikujjako obunnansi, then two kikujjako n'eddembe gy'olina nga Munnayuganda ery'obwebange okwetaba mu politics za Uganda n'emirimu gyonna munnansi gy'aba alina okwetabamu nga rights ze bwe ziragira. So ekyo ne tukirongoosa, kyekimu kye tulongoosezza. Ekyokubiri kyali ku naddala ku scope y'etteeka. Abantu baali batya nti bano Bannayuganda bali ebweru, esente ze baweereza, ebibiina ebiyamba mu bintu nga ebyokusoma, ebyobujjanjabi. So waliwo categories ze tuwandiise nti zino teziri mu ttuluba lw'ebyo bye tuyita agent wa foreigner, kubanga etteeka lisinzidde ku section 2.2 ebyo ebikolwa ebikuleeta mu ttuluba eryo erya agent wa foreigner. Ate okuba agent wa foreigner nakyo kyokka si kibi, tekimenya amateeka, okuggyako ng'okoze ebyo ebimenya amateeka bye tumenye mu tteeka. So mainly ennongosereza gye tukoze ebyo ebintu ebibadde bireeta okwemulugunya tubyadressinze ne tusharinga ne committee.
Abantu bemu exemptings nabo singa baba bakoze activities ezo ziri mu section 2 baba bamenya amateeka.
Obuzikulu obumenya amateeka, obuzikulu obumenya amateeka. Ne concerns eza banks ezaki ezokugamba nti eza church eza human rights eza ebyo byonna tubikozeeko. Kati mu kifo ky'okusaba olukusa declaring
Honorable Minister ekisembayo abannabyabufuzi bangi bibiina byobufuzi bizadde bagenda ebweru ne bakuŋŋaanya ssente zibayambako mu campaign n'ebirala. Wano mulungamya mutya kyekigenda okuddira
provided nti ozifuna nga togenda kusosowaza interest z'abagwira. Ekyo akukakwakulizo bino biri specific bwetwaze bwaffe n'obwebange bwa Uganda. Ebirala byonna ebimenya amateeka birina amateeka ga
kulaba nti Bannayuganda nga bayita mu bitongole ebyenjawulo bazze wano ne baleeta ebirowoozo byabwe. Kati kye bagezaako okukola kwe preemptinga committee nti Bannayuganda bazze etteeka ne balikubamu ebituli ne balaga ebikyamu. Kati bano bagezaako okuziba ebituli ebyo, naye eyo enkola ya legislation bweti ebeera mbi, kubanga ate bali Bannayuganda tebalina mukisa kukomawo ate ng'obwedda tugamba nti kati tuggulewo n'abantu baweewo omukisa bakomewo bakole ate era comment ku kino ekijja. Naye njagala obbalaga bakyusizza for example interpretation ya foreign agent of the foreigner. Luli babadde bagamba nti singa okola ebikolwa ebyo ng'obikoledde eri, kati bakomyewo bagambye nti kasita okola ebikolwa ebyo naye ng'ekyamazima kiri nti kasita oteeberezebwa nti okoze ebikolwa ebyo gamba mbu sente zoleese za kuseketerera mbu sente ezo enkolagana eyo ya kuwakanya government policy enkolagana eyo ya kuwakanya government interest kati gwe ofuukirawo foreign agent of the foreigner ekyo kitegeeza nti kati bannayuganda bonna mu Uganda olwaleero okujjako president etteeka gwe ligamba nti yetavunaanwa ng'ali mu buyinza ne bannayuganda ffena abasigaddewo miliyoni z'abannayuganda zonna 45 lino etteeka litufuula agents of the foreigner just because singa omuntu ava erinaga nti nambooze yakoze kino ateeberezebwa okuba yakoze kino lino etteeka olwo likuteekerako ow'ekipande nti ofuuse agenti waki wa foreigner n'olwekyo enkyukakyuka gye baleese egaziyizza kintu kino nefuula nti buli muntu yenna asobola ovunaanwa emisango gino nga bwe bagyogeddeko ate nga tegiri kiriya kubanga bw'ogamba omuntu nti kasita okola ebintu ebiri against government interest omuntu akubuuza government interest ngisoma wa ngisoma mu kitabo ky'okumanya nti kino government era government interest ani agisalawo nti kino government kyeyagala nti eno government policy kubanga bulijjo mutuwulirawo mu parliament nga tubuuza government erina policy ekiku kino ekintu ne bagamba ate tunnagikola ebintu bingi tebiriko government policy nga bw'owulidde tumubuuza ani anannyonnyola nti eno ye government policy ani oyo ali awo gwe tunaasomako kitabo ki oba kifo kimwe tunagenda ne tumanya nti eno government interest okujjako batutadde ku kisa kyabo abali mu buyinza bali mu buyinza minisita yasalawo nti eno government interest oba kino kiri against government interest kino kiri against government policy n'olwekyo etteeka lino olirabirawo ne speed kwe lijjira is bad faith bagezaako just kusiba kuteekawo mbeera ebawa omukisa okussa ku muntu omusango buli we bayagalidde nti nga balina etteeka lino bajja kukussaako omusango buli we bayagalidde kubanga kooti yerimala obiwulira negamba bambi okusinziira ku bujulizi obuleeteddwa namboozi oyo si agent of a foreigner naye nga ggwe ebbanga eryo lyonna oli muki mukomera bayidawo eno musango guli capital offense okusinziira ku kibonerezo n'olwekyo ebbanga lyonoomala mu kkomera ku remand ddene nnyo kati bajja kukwata nga bafunayo kati olaba nga oli faaza gwe bakwata ekalangala just okumususpectinga nti nno ono alabika nafuna ssente mba mu nsi z'ebweru akole ebintu ebiseketerera gavumenti ebintu ebiseketerera gavumenti tubibabuuzizza nti omuntu akola ki okumugamba nti aseketeredde gavumenti tebakinnyonnyola bagambye kisinziira era kisinziira ku bintu bingi kisinziira kati etteeka teribeera bwe bityo etteeka teribeera ambiguasi teribeera awo mbuno oli akuvunaana yasalawo mbwe okusinziira ku ekyo kyokoze awo oseketeredde gavumenti kati omwana wange Kadaama n'abeereyo n'ampeereza ssente nze nenkubyamu ebifaananyi nga neesimbye ku bwa kansala olwo nga nfuuse agent of a foreigner oba nze simanyi na mwana wange nze mmanyi nti omwana wange gyali ku bwa Kadaama buli kasente kampeereza ka musaala gwe bo basobola okujja naga nti abadde nga akajjeeyo mu bawalabu abatayagala Uganda so buli munnayuganda yenna lino etteeka ndirabye mujja liraba nga litandise okukola nti ate ne one time buli gwe banayagala ng'okuvunaana bajja muvunira nga akawaayiro mwe bamuvunaanira wano naye nze nsaba komiti ebeere y'amazima ebbanga lyonna buli muntu etteeka ng'otaddeko n'ebitongole bya gavumenti byennyini birivumiridde muntu ogu nsibambi yekka ogu atannyonnyodde na kiti kimwe yagidde yekka muntu ogu yekka yeyagambye nti etteeka ddungi nga n'omugambo obugambi nti gwe wali bazze ng'agamba nedda kakati komiti eneesinziira ku kyokukola lipoota ate egamba nti etteeka ttuufu eruli baakasuka etteeka ly'omwami ono ow'Emityana lumu sipiika n'agamba nti etteeka lino kye tuvudde tuligoba kuba abantu abasinga obungi baaliwakanya nti tetusobola tteeka abantu lye bawakanyiza era ne ansadi ngenda gibaleetera muwulidde mbasabye nange banzikirize njogereko gye bali kakati ku luno ate lino lwaki tulisaawo ng'abantu baliwakanyiza mu ngeri y'emu nga bwe twagoba lino teriteekwa nagenda mbabuulidde okusinziira ku mpisa za Commonwealth Parliament bw'eba ebuze ennaku 3 mudda mu biteeso byakweyozaayoza basebo tweyozayoza tukoze nnyo gundi weeraba ondabiranga ddala obadde mulungi gundi kino kitulemye kino tukikoze okujjako ekiteeso kyetusobola okuleeta mu nnaku 10 byebintu byebayita matters of national importance nga bwe tutakikolako leero Uganda esaanawo. Abo abantu abamu abatudde awo balina kubeera eri nga basiba migugu gyabwe kufuluma palamenti, abalala balina kugenda kunoonya ngoye za kulayira n'okulonda abantu abasatu be banajja nabo mu palamenti. Tulina kubeera mu pate nga tusiibula, bwe tutuula mu palamenti wali nga tuyisa biteeso byakwewaana byakwesiibuligana. Munaffe sipiika weebale nnyo, twasalirwa nnyo, twafiirwa gundi, bwe bityo. Nze nga bwe mbagambye mbadde wano okuva palamenti ey'omunaana naliwo katono, naliwo palamenti ey'omwenda, naliwo palamenti ey'ekkumi, mbaddewo palamenti ey'ekkumi nze no palamenti gye ndabye etuula n'esoosootula etteeka eriri controversial mu nnaku 10 ezisembayo. Mu Commonwealth palamenti waliwo gye bayita lame duck policy, nti bwe baba bakubyeko akalulu n'ogwa oba olemadde. Kati wano abakomyewo ku palamenti balinga 15, tokola bintu by'amaanyi, kiringa omukazi anaanoba tasimba mwanyi.
Mu njogera ennyangu gavumenti atone general asesetuse era twongeremu akaliro n'amaloboozi ga bannayuganda okulaba nga baseseetukira ddala okutuuka okusuula ebbago lino. Obudde tebunnakeerewa, otuba nga tubadde tusuubira okugenda okuwandiika ripooti ku Lwokutaano, olwaleero Olwokuna ne bakomawo ne bagamba nti bannaye mwategedde twejjuluddemuuko wano ebikwatagana ne bannayuganda okubeera nga baforena tubikyusizza. Bataddemu ekintu kye twalinga tukayana nga baagala okujja nga bakugwira bugwiza ewaka. Ne bagamba nti baagala okusaakinga anytime, amaanyi ga minisita baagala okugakendeeza. So ensonga nnyingi bazejjuluddeko era bagamba nti mu nsonga eno obeera nawaddembe ogera n'ofuna ssente kasita tozireeta wano kuyingira mu byabufuzi. Teffe kye tubadde tugamba nti baleke etteeka ly'ebyobufuzi kubanga weeriri wano ligavaninga ebyobufuzi. Waliwo wano n'etteeka lyebayita erya Money Laundering Act likolere ddala ensonga ezo wansi w'ekitongole ekyateekebwawo wano mu ggwanga ekya Financial Intelligence Authority. Kinoonyereze ku nsonga zino okuva we zitandikira mpaka we zikoma. Atone jeno kyalemeddeko ng'agamba nti ziri ssente zibeera ziyingidde mu bukyamu naye ka tuli ku ssente ne ziba nga ziyingidde mu butuufu kasita batandika oziteeka mu byobufuzi oba mu kuinfluencinga decisions z'abantu. Kati awo tukyalemedde era we tusuubira wetumugamba nti naye ssebo ogenza okukomawo. Governor Bank of Uganda yabadde wano, Financial Intelligence Authority babadde wano, Human Rights Commission babadde wano, ebitongole bingi nnyo naye wabyebuuzizzaako ddi oba ozze buzine proposals endala. Ekigendererwa mu bino wassebo ne bannyabo nti etteeka lirina kuva wansi, abantu abali wansi ne bali feelinga nti waliwo ekituli wano ne wano, ne bagamba nti twetaaga etteeka bwe liti naye si kutandikira eri waggulu nga bagezaako okuleeta etteeka lino. Naye tusuubira nti bannayuganda mu eddoboozi lyammwe Mwai Museveni n'abo bakulembera nabo baliwulira era y'ensonga lwaki bejjuluddemu. Tugenda kuddayo naffe tutuule ngera okwekenneenya bino bye baleeta oba biri mu kasupu ke twetaaga okukkiriza oba etteeka tukyaligaanira ddala. Era tugenda kwebuuzaako ne ku bannaffe abalala ba stakeholders abalala oba etteeka okusinziira ku proposals ze baleese ne byagala okwadjustingamu oba twetaagira okuba nga tukyalikubira ddala. Naye nga bwe tulaba tulowooza nti etteeka nga we liyimiridde etteeka likyali bbi, tetuweerebbwa kadde kamala. Bo baagala ne beebuuza mu nsi ez'enjawulo, ffe tetugenzeeko mu nsi za njawulo kwebuuza etteeka lino nga bwe likola abanga bye babadde balikozesa. Balitwala sipiidi ya yiriyiri. So kyetulowooza nti si kyabwenkanya era kyetaaga etteeka lino ne likasukibwa ebweru. Okujjako abantu nga bawandiise buwandiisi n'essaawa eno interfacing ne other stakeholders yaggaddwawo era kyenyinza okubategeeza nti tuli scheduled okugenda okwesibira mu bisenge eby'emunyonyi eyo okutandika okukola ripooti gyetusuubiramu ebintu nga bibiri ekasuka ebbagi ebweru oba bana basazeewo ne bakola nga bebasalira okukola bulijjo aye tunalaba kyekiddako naye okusinziira ku maloboozi g'abantu agalabikira wano nga mwalabikiramu omuntu omu yekka ng'asapootinga ebbagi eryo tusuubira nti ffe ne bannaffe bagenda kukaanya abantu nga bwe basaba ebbago lino likasukibwa ebweru.
Amateeka n'aka defense gye tuyita joint committee etunula ku tteeka lino erya sovereignty of protection of sovereignty bill tufunyemu ku ssanyu ettonotono nti tubadde tuli beeteefuteefu nga tukutte ebijambiya ebyokutematema etteeka lino tuliyuzaayuze tulabe nti ligendera ku ebyo Abannayuganda bye babadde bagamba naye tufunire omukisa mulungi. Attorney General yazze ne nannyini tteeka Minister wa Internal Affairs ne batuyamba ne baleeta ennongoosereza bamaze okulitematema bagyeko ebisongovu bingi ebibaddeko babigyeko ekyokulabirako bakyusizaamu ekigamba nti abaana baffe abali wabweru ba diaspora bagenda kuyitibwa bagwira mu lino etteeka ekyo bakigyewo kati omugwira yoyo gwe tumanyi nga mugwira ne baleeta ne bajjamu n'ebitongole bingi nnyo n'abantu bangi ababadde nga mu tteeka nga eribadde babadde nga balimu naye kati babagjeemu. Ekyokulabirako etteeka kati liggyeemu kyaki ezi zonna, etteeka liggyeemu emizigiti zonna zivuddemu, faith based organization zonna zivuddemu, etteeka liggyeemu all regulated institutions under an act of parliament. Nti institution ezo zonna ezirina amateeka agazitambuza nga banks, nga law society, nga ba accountants, nga ba companies zonna ezo ezirina amateeka agazitambulirako zonna zivuddemu. Etteeka liggyeemu esente ezijja muno nga za business, esente ezijja muno za contracts, esente ezijja muno nga za loan, esente ezijja muno ez'okuyamba families abaana ze basindika wano kuyamba families zaabwe, ebyo byonna Attorney General abiggyeemu. So n'olwekyo mu kakiiko kituyambyeko okulaba nti kati Attorney General agezezaako okufundawaza etteeka ng'etteeka saawa zino ligamba nti omuntu yenna anaaba nga afuna ssente okuva wabweru bwa Uganda nga ssente ezo zijja wano n'ozifuna nga zakuyamba oyo omuntu wa wabweru okutataganya enteekateeka ya Uganda mu politics oba mu policy, ezo ssente zogenda okwewandiisa nga agent wa foreigner oyo yakusindikidde ssente, era ezo ssente gavumenti zeyagala ogenda oripootinge. Biri ebibaddemu nti miliyoni 4 okweyongerayo ogenda wa minisita n'ofuna olukusa nabyo bivuddemu. Saawa zino tugamba nti bw'oba ofunye ssente okuva wabweru nga oli agent wa foreigner nga ssente ezo ozifunye za kukuyamba mu bya politics bya wano in the interest of a foreigner oba mu bya policy in the interest of a foreigner, ezo ssente zogenda okwanjulira gavumenti nti twafunye ssente zisooka miliyoni 4. Okutwaliza awamu ababaka bagamba nti kituufu mukyalimu obuntuntu, era kati saawa zino bwe tugenda okweyongera okwetegereza kuba Attorney General kyaleese si kyekyenkomerero, yaleese ennongoosereza kati ate akakiiko kaddembe okwongera okutunulamu ezo ennongoosereza era ne twongera okuzikutula okulaba nti etteeka erigenda okufuluma ligenderaku ebyo Abannayuganda bye bagamba nti etteeka terijja wano kufundawaza civic space, kufundawaza ebya politics bya Uganda n'okulinyirira eddembe ly'abantu, nti etteeka tebalireeta kulemesa abantu abagala okukola bizinesi zaabwe awatali tabu. So ebyo byonna tugenda kubitunulamu tulabe nga nte akakiiko keeyongera okwetegereza ensonga zino zifulu.
Kyetegeeza obuntuntu nga bw'obuyise oba ebisigadde birumirira mu bbago ly'etteeka lino, amendments nga bwe zikoleddwa mugenda kuddamu muyite abantu mubeebuuzeeko.
Akakiiko Attorney General ne Minister wa Internal Affairs ebirowoozo bye yalese bibadde nga biddamu mu bigambo ebyo Abannayuganda bye babadde boogera wano mu kakiiko, ku radio, ku social media. Kati akakiiko kagenda kutuula keetegereze nti zino ensonga Attorney General zaleese ziddamu ebibuuzo ebyo era zijjawo omuliro. Singa ensonga ezo ziba zijjawo omuliro ogubaddewo era nga ziddamu ebibuuzo abantu bye babadde babuuza, kiba tekyetaagisa nte kuddayo kuyita bantu kukola comments. naye singa wabeerayo ensonga nga nte ekyalimu eggumba tujja kuyita abantu era batuwa amagezi kuba bino byonna ebibaddewo Attorney General byayogedde era byaleese bivuddemu birowoozo by'abantu bebabadde boogera wano mu kakiiko ne ku social media ne mawulire ga Uganda yonna. Demanding that there should be a change of language. Ugandans came to the committee, very many stakeholders came to the committee and said either the bill should be rejected or in the alternative, substantial amended. And the Attorney General and the move of the bill, the Minister for Internal Affairs have preferred to amend their own bill by way of responding to the concerns raised by stakeholders, Ugandans here in Uganda and those in the diaspora. So the amendments speak to the concerns of the people, and the bill now, in my view, has been given surgery to remove all the rough edges. I'll give you an example. We now have a refined definition of a foreigner to include the foreigners we know, either a foreign company or a foreign person or a foreign multinational organization or a country. It cannot be that we can define our own people to mean non-resident Ugandans. That one has been removed. Then we have provided for exclusions. There are so many exclusions that have been provided under Clause 2. For example, all faith-based organizations have been excluded. All banks, regulated institutions under an act of parliament, including banks, including professional organizations like law society, like accountants, like engineers, all those have been excluded. Universities and institutions of learning have been excluded. Money that comes here for foreign direct investments, money that comes here as loans, money that comes here for family support, money that comes into Uganda for charity. So all those ones have been excluded. What is now left in the bill is clear and precise. Money that comes from outside Uganda to come to Uganda to support the influence of a foreigner in destabilizing Uganda. That's the money that has been left in the bill. A foreign agent, a foreigner, a government or a company funds an individual in Uganda who we are calling a foreign agent to destabilize Uganda. That's the money that is now left in the bill. That foreign agent has to register, and that foreign agent must declare the amounts of money that has been received for that particular activity.
In the question of evidence, how would one tell that this person actually is working in the interest of a foreigner?
First of all, you can declare yourself as an agent of a foreigner. That's the first one. Number two, the benchmarks now of who is a foreigner of a foreign agent are now stipulated in the bill. So if you don't declare and then you receive money, and then the government finds out that you received the money from a foreigner and you didn't declare, and that money is being used in the interest of a foreigner to destabilize Uganda, then you'll be subject to the law if it is passed. Yeah, because you can refuse to register, and even if you refuse to register, the Financial Intelligence Agency, FIA, can track all the monies that have come in Uganda. So if we can know that yes, Honorable Baka received 1 billion shillings, and then we track that money, how was it used? He used that money to go and the campaign universal primary education. Why? Because there is a foreign agent who funded him such that he can decampaign UPE such that Ugandans can remain illiterate. For example, I'm giving an example. So once that trail has been made, then you are subject to the law and the penalties are there. Of course, the other complaint has been that the penalties are very harsh. 4 billions, 2 billions, 20 years in prison. All those ones we are going to look at to try to regulate the law in a manner that is not so suppressive.
Honorable, as the committee, have you put into consideration that this intended legislation could create fears to those people who are in the foreign country or even foreign agencies trying to send money to this country, because the money might end up getting to the wrong hands?
Creating fear is one of the purposes of the law. Creating fear is actually it's a deterrent, because if you have been sending money to Uganda for influencing negatively the activities in Uganda, that's the money that we want to know. We are not even saying don't send. We are saying send it, but we should know. We should know that Honorable Baka has money for destabilizing the country such that we can be able to deal with you appropriately. So one of the purposes of the law is to send a warning to foreigners who want to destabilize Uganda negatively. Not foreigners who bring money for charity, money for investment, money for research, money for faith-based organizations. That money, there is no problem. But that one who is going to send money to destabilize Uganda for subversive activities, now we will know that things are now tough. So the foreigner will know, but also the Ugandans should know that if you receive money to do wrong activities against the interests of Uganda, in the interest of a foreigner, you are going to be subject to this law.
Why is it so hard to empower the FIA to do an oversight on all the finances?
The Attorney General has explained that very well. The Financial Intelligence Authority tracks all monies that come here. And all the money that come here, we have illicit money, that is FIA, Financial Intelligence Authority. It can track illicit money. This law deals with both illicit money but also legal money. Money comes here legally. For example, you receive it legally as Honorable Baka. It has come from a source probably from the UK. It comes in legally and then you start using it for other purposes.
Kitoleko Robert nze member parliament we ba munane. Ntula kakiiko akalina ekintu kino. Bye bajjeemu era balese biggule. Kati bwe basigadde okukuba akakunguntu okulaba ani ono n'onaani tewaliwo kisibe. Kati ekiriwo kyonna ekikulu nti bajjeeko ekkooti ne basigaza essaati naye ng'oli afulumye mukolo n'oba eraga nti ogenze kukyusa otadde obazze bajjeeko ekkooti kati balabika nga abakyusizza naye bwe bazze nabyo teriiyo kikyuse kuba ekisooka kati kyongedde kutunula nti bo akwata yakulinaku ate buli kimu kati etteeka si lirina oli asalawo busazi ku lulwe. So kati Attorney General ne banne ffe tubadde tubagamba muyite bannayuganda kubanga bo baawadde amagezi ku birala kati bino bye muleese leero tebabimanyi temubajjaako ndowooza zaabwe kuba kati bino bye muwagiseemu ebipya bannayuganda si bye bataddeko endowooza zaabwe. So mmanyi bulungi nti pureesa gye baawulidde yeeringa eyagala okugjawo kyo naye bannayuganda mumanye nti etteeka lyammwe lyerimu lyennyini bakyusizza kkooti olufulumya ekizimbe ne bajjira mu saati naye nga beebamu era n'abivuga y'omu era n'ebigendwa ebibi eby'etteeka bye bikyalimu teriwo kikyuse.
The Attorney General to come at another stage, we are at liberty to invite him. This opportunity is for whoever has anything to say. If you have nothing to say, keep your peace.
Further procedure, Chair.
Yes.
Earlier on, you had guided. Earlier on, Honorable Chair, you ruled actually that in this meeting we would receive what the Attorney General is presenting, the amendments that he's proposing, and the Attorney General would be available at a later date to answer any queries that we have. Now, when you open it up and you ask honorable members who have questions to pose them right now, it's in contradiction to what you had earlier on guided. And bearing in mind that this is the first time we are setting our eyes on these documents. We have not perused the matrix with the Attorney General who has provided answers. Quite frankly speaking, we need time. Members may have queries, but after you dispose of those queries, Chair, as you have already changed your stance from the way it was in the beginning, you will likely change your stance that now we've discharged the Attorney General fully of his obligation, as you had earlier on stated.
Honorable Anna.
Yes, sir.
I have not changed any situation, any stance. What I've said and what I want to repeat is that if you have any matter that for which you want a clarification from the Attorney General and the Minister, they are here. You can raise it. The Attorney General and the Minister are available to us anytime we want to invite them, including tomorrow, Saturday, Sunday, or even Monday. So for now, colleagues who have anything to raise with the Attorney General and the Minister.
But
Please,
Chair, it is still a departure from what you earlier on told us.
Let me make my ruling. Honorable Anna, if you have nothing useful to add to today's deliberations, you wait for that time when we invite the Honorable Minister. But for now, any member who has any matter to raise with the Minister, he's here. I cannot discharge the Minister when members have issues for which they want a response.
No. We just want to question him where he skipped some stakeholders.
Chair, I want
is he allergic to UPC? UPC is not.
Can we have Honorable Fox?
Chair, just take this. Take this procedure.
Okay, Honorable Dude.
Chair, on page 2 of the presentation by the Attorney General, the joint statement, it says, we refer to the letter of the chairperson of Parliamentary Committee on Defense and Internal Affairs dated 29th April 2026, forwarding legal issues raised by the stakeholders. Up to the end, I don't want to waste time there. But Chair, my point is, at what point are you going to forward my letter? Because this is the letter of the chairperson. We never sat and agreed on the issues to be sent. The issues raised. So I'm asking on behalf of all the members, at what point are we at liberty now to write individually? Because this is a joint committee, but the chairperson defense wrote alone. Forwarding his issues. The legal committee chairperson has not yet written. The members of parliament have not yet written. So the Attorney General has responded, which is still good, on the letter written by defense. Now we are asking, at what point are we going to write now to the Attorney General to jointly answer the concerns of the committee, given this marshalling?
Let me respond. Stakeholders, the other day you didn't attend that meeting. We said here, on Tuesday in the evening, we said the Secretariat should do a matrix of the issues. And those issues should be prepared and referred to the Honorable Land Attorney General. And those issues have been shared on our forums.
No. Honorable Chair, I will
they have been
protest
shared
because I was present in that meeting throughout.
Honorable Chair, maybe
there was no
Can we have the Attorney General say
maybe
something?
a matter of procedure. Can we be excused so the committee can deliberate on its internal matters? And then when at another time when you're ready, if we are available, we can come back. No. Because even if we don't come back, you'll have to make a decision.
Yes.
Yeah.
Chair, that is the proposal of the Honorable information.
Chair, I have used my eyes to look at the letter from Attorney General. When you look at the letter, it's actually addressed to all the chairpersons. If you look at the beginning, honorable chairpersons and honorable members, it captures all the two committees. I want us to look at that. So the response may not be isolated strictly to the defense committee, but it takes into account that all the chairpersons in respect of all these committees were responded to by Attorney General. I want to politely request, Chair, that we be allowed to raise. There are certain critical issues that really I would want the Minister and Attorney General to respond to, which are very fundamental. If we can be permitted to raise, then anything pending, subsequently we can always solicit for responses from them. But if we could be permitted just to raise them for the benefit of all of us, we'll appreciate it. I've
been saying all along. Colleagues who have issues to raise, Honorable Numbers, you have issues. Can you raise them?
That we redraft, and I'm framing this as a question. Would you be amenable to redrafting clause 2 as follows? This act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platforms. By so doing, we shall be deleting clause 2, subclause 2, and the words "for the avoidance of doubt, this act applies to an agent of a foreigner," which I think is basically repetitive. Would you be amenable to
redrafting it as such.
Yeah, I think that would be okay. Clause. It's good when you have things that would create doubt. You put them there because the clause tends to call you to it. So if you say the act applies to an agent of a foreigner, you read it, people may not necessarily look at it, but this is a call to. So I don't have a problem in terms of drafting. It's a drafting style. I would recommend to the committee that the use of for avoidance of doubt, for clarity and calling to is actually a good practice.
Okay. My second question, which is the last one, if you look at clause 22, clause 22, and it has a total of, I think, 4 sub-clauses. Would you be amenable to us deleting the entire clause if we are satisfied that the provisions of the Anti-Money Laundering Act sufficiently covers the evil that you want to cure here?
Not quite, because I know and is dealing with illicit funds. This law is not addressing illicit funds. It's addressing legitimate funds used for a wrongful purpose. But you can have illegitimate funds which are used for a lawful purpose. So the Anti-Money Laundering Act does not care whether you're using the money for a lawful purpose or not. As long as it is illicit, it catches it. Here, we are saying that even if you have legitimate good money, it should not be used for these purposes. For example, I get my salary. I'm a foreigner. I get my salary. I have all my pay slips. You can show me where the money came from. The whole money trail is okay. So when it goes to money laundering, they will say, cleared, because you have explained where all your money came from. But I'm using it to disrupt, for disruptive activities here. That's where this act will come in. I would not be comfortable. Thank you.
Honorable Chair, I yield.
I have a very fundamental problem with the structure of this entire bill now, especially in light of the fact that the amendments are silent on the punishments, the severity of the punishments. And you recall, because Learned Attorney General, Senior Counsel Chiriowa Chiwanuka Nsumikambi, when he was giving background, he said, you've listened to the stakeholders. And one of the issues that was raised by the stakeholders was the nature of the punishments. And the amendments are very silent on them, both the custodial and the fines. Number 2, Chairperson, when you look at the provisions that establish offenses, with the greatest respect, Learned Attorney General, they are too broad and imprecise to be penal provisions. For example, look at page 11. I'll begin from page 10. Page 10, you say foreign policy means a policy developed by a foreigner and has not been adopted by a government. So now the question comes, what then is policy? Go to page 11. Interests of Uganda means the national interests of Uganda based on the principles of national interest and common good enshrined in the national objectives and directive principles of state policy as provided for in the Constitution, laws of Uganda, and government policy. Learned Attorney General, when I work against the interests of Uganda, I am committing an offense under this law. But you are defining interests of Uganda in a very broad manner. Very broad, very elastic. How can that be a penal provision? And how does it not really run foul to the Constitution in terms of clarity of offense? Chair, I go to political activities, again on page 11. You are in effect killing activities of political parties, in effect. Because you are saying political activities means an activity aimed at influencing the enactment of legislation, formulation of policy, or decision-making of government or the people of Uganda. And this in itself, Learned Attorney General, is problematic. What is wrong with influencing enactment of legislation? What is wrong with that? What is criminal with that? What is criminal with influencing policy? Formulation of policy or decision making. What is criminal with that? Now, you are talking about under page 11, political activities. I want you to look at how you describe political activities from beginning to the end. In effect, you are, this is a multi-party side. You are killing multi-partyism, political parties, in effect. When you look at this, and even in NRM will be swallowed in this in the future. So I also find your definition and description of political activities very broad, and they run counter to the spirit of multipartyism. Chair, application, page 12. Wouldn't it be proper, Learned Attorney General, for you to specifically state who really this act applies to? Who? Because when you are talking about the application, you give activities and the like. Who is amenable? Under what? Who is under the purview of this bill? Are NGOs involved or not? Are churches involved or not? Are mosques involved or not? In specific terms, on application. Chair, you go to page 23, clause 13, prohibition of economic sabotage. Again, an attempt by my longtime friend, the Minister for Internal Affairs, to rephrase creates a bigger problem. And I want to continue alluding to this. Learned Attorney General, this is a penal piece of legislation. Penal. And when you look at this, the impreciseness, the broadness, makes it very problematic. You are talking about a person who publishes false information. Now, who determines what is false and not? You are talking about activity that weakens. What is to weaken? What is to undermine? What is to weaken? What is to undermine?
Information.
And you are talking about economic system of viability. What are they? What are they? Realistically speaking, we are talking about a penal provision. And it is these provisions that are going to be subject of abuse, especially by law enforcement. So I would rather, Learned Attorney General, that in making these statements, let us be very specific, let us be precise. Chair, I would seek at least a comment from the Learned Attorney General. You talk about registration of an agent. registration of an agent. What rights do I get by being registered? Because there are prohibitions here. This bill is creating prohibitions, it's creating crimes. But then there is also a requirement to register. What does it mean? If I register, do I now qualify to engage in these activities? Is that the implication? What ideally is the objective of registration? Because ideally there are prohibitions here. Crimes are being established under this piece of legislation. Finally, Chair, on page 29, declaration of sources of funding. There are two issues. Number one, on 21 and 22 Learned Director General. Number one, when and at what stage do I make the declaration? When and at what stage do I make the declaration? Number two, if there are, because in clause 21.1, you make reference to the Anti-Money Laundering Act, and the issues to do with declaration and source of funding, in your own view, but also in the presentations we received, are matters that can easily be covered under the Anti-Money Laundering Act. Learned Attorney General, don't you think will be engaging in double reporting, which in effect will be onerous for anybody receiving money, and then you are requiring them to declare under the Financial Intelligence Authority, then here under the ministry, and the like. Chair, those are my concerns as of now. I will do. But since you have compelled us, I didn't want to use the word duress, since I'll leave it at that. But I thank you, Chairperson.
7. Let's look at page 18. On the development of government policy. I had a particular issue, a point of concern with the proposed amendment on paragraph 4, 7.4. When you read paragraph 1, it surely demonstrates and shows that in the Constitution, government shall determine, formulate, and implement the policy of government. When you read it 2, it talks about government policy. But when you come to 4, it says an agent of a foreigner who knowingly develops and implements a government policy. Now, you have already defined the person who develops government policy. Any policy which is not developed cannot be a government policy. That is, for me, this would be a bit redundant if you look at 4. That is my one observation. Then 2, I also wanted to take you to, maybe I'd gone to paragraph 13 on page 23. When you look at, I want to look at it this way. Yes, this is a penal provision that we're developing. And in law, we appreciate that as a principle of legality, which is very clear. If you look at Article 28:12, it says, except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and a penalty prescribed. That's very clear. But when you look at this particular provision that we are developing, it talks about an agent of a foreigner who knowingly publishes false information or participates in any activity, any act or activity that weakens. My understanding with this is that this particular aspect of this provision creates a lot of uncertainty. It creates a lot of uncertainty, and it would actually be a bit so ambiguous. It could create difficulty in the court system when they are handling offences within this provision. I would want to draw your attention to that, to look at that particular provision. Then you go to page 28 on the certificate of registration. The certificate of registration, upon a recommendation of a department, the minister has 14 days to issue. And if he's not issuing, he has 14 days to give a reason for not to issue. If you look at 17 and 18. My concern with that, what we have done in this particular provision is to open through 18.3 that any person aggrieved by the decision of the minister may apply to court of a competent jurisdiction for legal redress in accordance with applicable law. One, clarity ought to be put in this provision, even the court, which can be able to address this. But I'm also thinking, if we have said the minister either issues this certificate within 14 days, there are situations where the minister even keeps quiet. He has not communicated the reason why. He has not done all these things. I think we are also, in a way, creating a situation that we are telling Ugandans, go to court. Why don't we presume that while the minister remains silent upon not undertaking that activity in 14 days, let the certificate be deemed issued instead of referring Ugandans to go to the courts of law? Thank you.
The word publishes, information appears. I'm of the view that we should replace it with carries out any disruptive activity. Where publishes information, where it appears. And we replace it with carries out any disruptive activity or does any act prohibited under this act. My reasoning is based on the fact that that offense, it affronts because it affronts the freedom of speech, as per the cases of Andrew Mujuni Mwenda and Charles Onyango Obo. The second clause is 14, 15, and 16. Attorney General, I have heard well why you tried to draw a distinction between the Anti-Money Laundering Act and this bill. Me, I'm of the view that why can't we enrich some provisions in the anti-money laundering so that because it has already put up structures and institutions and it is well already doing the work to do with money laundering, this issue to do with this department, we create a department in that authority. And in this bill, wherever it appears the word department, we substitute it with the word authority, meaning FIA. Honorable Chair, on clause 18, I'm of the view that we delete the words fit and proper person. To me, it appears to be redundant, since the applicant will be examined by the department and advise the minister. So now introducing another test would delay the whole process. The minister should only consider the report from the department or now the authority, as I have already proposed. When you, on clause 18, okay, you consider, okay, thank you. Delete and the,
Is there a matter?
I was of the view of deleting the word fit and proper person, because it will be creating another long route. Yet there is already a test which has already been created through the department, now stroke the authority, which have already proposed. Clause 19, let's propose a timeline for the renewal.
Stakeholder engagement. It appeared to me that in drafting this bill there was no consultation even within government. And I pull out 3, maybe 2 departments of government that came and submitted rejecting this bill or proposing withdrawal and substantial amendment. The governor of Bank of Uganda and his deputy and another appeared here and took us through the economic consequences of this bill and painted a very grave negative consequence of even attempting to move with this bill. The Uganda Human Rights Commission, a statutory body, appeared here and made submissions, first confirming they were never consulted, but also rejecting the bill. There are also other credible stakeholders, including the Financial Intelligence Authority, appeared here. These are government agencies. Let me limit to those 3. In their submission, they opposed this bill and thought that if they were consulted within government, they would have clarified and helped government better. I want to ask you, within these 3 days and with these proposed amendments, did you consult within government those entities, for example, Bank of Uganda? Did you go back to them so that even these amendments you are proposing, we are sure has addressed their concern? And I'm raising this because, Learned Attorney General, throughout this process we have been giving the legal lenses to this bill. But the stakeholders brought to us an economic lens. They brought for us a medical lens, Uganda Medical Association. The International Association of Chamber of Commerce, something like that, the British, American, brought for us an international perspective in terms of trade. I have seen you have tried to just exempt, because they appeared here, exempt. Bank of Uganda, for example, and the Uganda Bankers Association, they are also stakeholders that they trade, but they are also in the middle of the foreign agent and government. What you seem to have addressed here is that we have allowed them, if they are bringing, say, meeting capital requirements, let banks go on, so they are exempted. How about their role as an intermediary? That the bank has already, for example, observed that so and so has received more than 400. What is that bank required to do in the circumstance? So, without going to that, I want you to confirm, did you make consultations, and can you put on record the key stakeholders that you have met which guided these amendments that you have proposed here? Thank you.
It is largely creating offenses for either undermining a government policy, criticizing, and the like. And from the little law I have studied and I know, what cannot be a defense is ignorance of the law. But it now looks like ignorance of a government policy is becoming a crime. Is there any law in this land of ours providing for development of a government policy and its publication for the knowledge of all Ugandans that this is a particular government policy for everyone to know? Because it looks like under this proposed bill, ignorance of a government policy, however, nobody knows how it comes up, becomes a crime. That's one. Two, I want the Attorney General to confirm to us that the functions and services of government under 6th schedule, be it on environment, be it in elections, be it in education, where Parliament has made an act of Parliament under any of these schedules, are exempted from this particular bill. If Parliament has made a law under any of the functions under 6th schedule, whatever is done under that act is exempted under this proposed bill. Lastly, from me, I have looked at the response from the Attorney General, especially in the matrix. The issue of constitutionality still remains vague from the response. Because when you look at Article 1, what is sovereign are the people of Uganda. But this particular bill, when you look at it, there is nothing in it that touches the sovereignty of the people of Uganda. What actually this bill is about is the protection of the state. Would you mind if you even changed the title from the Protection of Sovereignty Bill to the Protection of the State Authority Bill? And in view of your proposed amendments, would you even mind if you changed the memorandum? Because when you look at the memorandum as is and your proposed amendments, you fundamentally go against the memorandum itself. Would you consider withdrawing this bill, coming up with a proper one that will rhyme with your proposed amendments and my proposed title of Protection of the State Authority, but not Sovereignty Bill?
Part 8, implementation of government policy. Then it goes to 19, part 3. All along, where we would find a person and an agent of a foreigner, we are deleting a person. But I don't know in this why in this part 3, the word a person has remained not deleted.
Is it clear to you?
8.3. So they have been both of them used.
Okay.
Thank you. And this is in particular Ministry of Labor, employers, and trade unions who receive funding from international labor organizations as a tripartite for the purpose of collective bargaining for the workers. And here, I would think that the trade unions needed to explicitly be mentioned, be exempted. Why is this money is come collectively, funding government, funding trade unions, and also funding employers? So if they are not properly explicitly put here, I feel very uncomfortable because trade unions has a representation of over 10 million workers in this country, and therefore they should not be treated as the NGOs or civil society. And that's what I'm raising to be included here as exemption. I thank you, Chair.
On page 25,
is clause 16, consideration of application for registration. And in it, the task is given to the department, and that person, the department. First of all, the flow is not very good, because if you read, where an application for registration is made to the minister under this act, the minister shall forward the application to the department to conduct inquiries into the suitability of the application and the applicant, and make a recommendation to the minister within 14 days from the date it is forwarded. So, but what I was saying is now listed under the outcomes of the inquiry. My concern was, isn't this, how do you find it, Attorney General and Honorable Minister? Are we not, wouldn't it have been better for you to provide for the functions of the department? Because this seemed to resonate well with what the department is supposed to do as functions of the department. The other concern is on page 27 about the certificate of registration. Here the minister is said to is directed in the first place, shall within 14 days upon receiving the recommendation of the department consider the application and may, if satisfied. This to me is a contradiction, because if the department has made a recommendation and the minister is directed by this act, when it comes to be an act to issue a certificate, for me I find this may, again, if satisfied that the applicant meets the requirements, issue a certificate. I think he should. He should. Because when we use may, it is again a discretion as to whether he should issue or not. So for me, I think the minister acts on the recommendation of the department, and when it is satisfied that this is issued and not may. Secondly, it is indicated here that the minister may grant a certificate of registration subject to such conditions as the minister may consider necessary, and may from time to time add vary. That latitude is too much, and this is where the stakeholders were concerned that the minister may abuse his authority to determine otherwise. So I thought we also need to be express in as far as this provision is concerned, and indicate and or insist that once a recommendation has been made, the certificate of registration is issued, and not again introduce new conditions that the minister may, when he is not well, or he might have to, when he is not very well. Yeah, then I have also observed in the same page, the person, this one has been canvassed by Honorable Kiror. He has indicated very well that for us to say that a person may have to go to court, this is a bit cumbersome and troublesome. I think this is concerning to members. Refusal to grant certificate of registration. The minister may, where he or she is satisfied that after conducting an inquiry that the applicant is not a fit and proper person. This was also raised, and I think it risks, there is no express provisions on the grounds against which the minister may refuse or refuses, and that injures the freedom of or the right of the applicant as provided for in Article 44, because we are not allowed to make a law that derogates the rights of a person, and even which goes against the rules of procedure, in our rules of procedure.
Those are the observations that I'd wanted to raise. Lastly, the inspection issue, page 33. A person appointed by the minister may, upon obtaining a court order, at any reasonable time inspect the premises. Why do you go to obtain a court order? For what? Is there a problem? I thought there should be a provision, first of all, that there is suspected subversive activity within the premises of an agent, and then the person so appointed by the minister gets cause to want to inspect those premises. So I thought there should be a provision indicating where a person has been indicted or is suspected to have, contravened the act. Then he can be allowed to inspect the premises of the agent upon obtaining a court order, so as to enter those premises. I thank you, Chair.
Like, it has moved from making Ugandans living in the diaspora to look like foreigners, to making every Ugandan who carries out particular actions become a foreigner themselves. So you no longer need to leave the country to be declared a foreigner, but you need to just be within 2-2 to be a foreigner. I really would like the Attorney General to gloss over that one, because I know there are many more defects that we see, but that one is the one I found the most deplorable for now.
John? Thank you, Honorable Chair. I am just correct my assumption here, Honorable Attorney General. If a Ugandan citizen raises money from outside Uganda for purposes of furthering his political aspirations and activities here in Uganda, do I assume correctly that this law does not apply to that person? Number two, in determining whether a person or entity is acting in the interest of a foreigner, must it be express or can it be implied? Thank you.
Honorable Namboze.
Thank you, Mr. To have ceremonial debates of how we have fared and holding farewell parties, not opening up a controversial debate like the one we are handling right now. Mr. Chairman, I would therefore request that at your convenience, you allow me some time to make a full presentation on that one topic and what I think about it. To Mr. Chairman, the amendments as proposed to the bill, in my opinion, have substantial effect on the bill. And I would like to know from the Attorney General and you, if it would not be proper thereafter to reopen public engagement, because now, like Honorable Anna has now pointed out, this ceases to be a law governing people outside Uganda, but people, even including those who are in Uganda, suspected that as soon as I'm suspected that I've done such and such an act, I become a foreign agent. So wouldn't it be proper that we reopen the public hearing to be able to get to know what the stakeholders think about these changes now being proposed? 3, Mr. Chairman, the other day the Attorney General brought this bill, and today, after hearing from the public and other stakeholders, he's proposing a number of changes. Doesn't he think that given more time and opportunity to hear from more people and entities, he would make other
changes to the bill. And I want to know for sure what other changes might he be thinking about bringing as we progress into the processing of the bill. Lastly, Mr. Chairman, the prohibition of interfering with the electoral process as spelled out here at page it is said in the bill, the clause provides that a foreign agent is not supposed to interfere with the electoral process of Uganda. However, there is an exception that unless when that person is a candidate, that this does not affect candidates. But, Mr. Chairman, elections are not for candidates alone. They are for everybody. So, isn't this law now differentiating some people? Because you say, when you're a candidate, 13. It is clause 11. About elections. Yes. Prohibition of interfering with the electoral process. Say, an agent of a foreigner who is intentionally, influences the will and the consent of any person to decide on how he or she shall be governed, contrary to subsection 1, commits an offense and is liable on conviction, blah, blah. Then in 4 they say, this section shall not apply to a person who has been nominated by the Electoral Commission in accordance with the relevant Act of Parliament and is canvassing for votes in accordance with the Constitution and an Act of Parliament. So when a foreign agent is a candidate, then the law does not. Because under our laws, the definition given to a foreign agent include even people like me, because it touches on just my actions. It is my actions that make me an agent of the foreigner. So if I'm a candidate, I'm exempted. But if I'm not a candidate, I'm not supposed to participate in the electoral process. So I think that the Attorney General should revisit that particular clause. It's not clear. Because a candidate is allowed to commit offenses. And it also touches the issue of equality before the law. Mr. Chairman, there are also these general observations. Mr. Chairman, they say that a person is considered a foreign agent if that person does some acts. But I want to ask, as established by who? Number 1, clause 1, an agent of a foreigner means a person who engages in any activities referred to in section 1. And I want to ask, as established by who? Because it is like as suspected, as established by court. So I become a foreign agent because I've been suspected of doing some activities, all have been established to have done, I've been convicted by court. So the definition has, we have moved from the frying pan to fire by these changes. And then they say, any person who undermines or well aware of the government, the government interest the interest of Uganda. So the interest of Uganda, as defined by who? What amounts to the interest of Uganda? Do you have a statute where the interests of Uganda are listed? So what amounts to? What can I call the interest of Uganda? As established by who? As determined by who? By those in power? What amounts to the interest of Uganda? And then lastly, about the general questions, Mr. Chairman. They say, you are not supposed to do this and this. And under the law, they are prohibited. Those particular activities are prohibited. But then they say, so once they are prohibited, Mr. Chairman, I establish that these are crimes. It's criminal to do such and such an act. But then again they say that you can be permitted. Do you have anybody under the sun who can permit me to commit a crime? Even if it is a minister. That a minister can permit somebody to commit a crime? If it is a crime, it's a crime. If it's not a crime, if it can be permitted, then it's not a crime. Mr. Chairman, finally, I'm a journalist, and after here I intend to go back to my job. In 2004, in 2032, in 2004, we had a case of Onyango Obo, the Daily Monitor case, and Andrew Mwenda. And they had written a story about Kabila, that he had paid Uganda in Igolodi for the support. The matter was taken to court, and finally what came out was that the court struck out that particular provision about the issue of false news. So under this act, is the Attorney General trying to smuggle back what was struck out by court, and by that offending Article 92 of the Constitution, the issue of false news, and what amounts to false news? Who determines what is false news? And more particularly, that particular provision was struck down by courts of law, allegedly offending Article 92 of the Constitution. Thank you, Mr. Chairman. I wish to end there for now, but ask you to grant me some.
Is on application, page 13. The Attorney General and the Minister, they are talking about the applicability, and then on 2I, where you are saying, and any other activity declared by the Minister. Attorney General, are you not giving Minister the authority now to prescribe?
That was deleted, Honorable Kahonda. I think you
No, it's what I am following. What the Attorney General presented is on page 13. On page 13. So, to me, I think, Honorable Chair, this clause should be deleted. And then on page 26, on page 26, starting from page 25, consideration of the application for registration. And then 2B. 2 says the department may conduct the following inquiries to ascertain the suitability of the applicant, of the application and the applicant. And then B says whether the applicant or directors, in the case of a company or legal entity, have ever been convicted of an offense. Mr. Chairman and members, we have had people whose cases have been fabricated. and they have been taken to court, others have been convicted, including some of the ministers who are serving in this government. Attorney General, wouldn't it be proper that we unpack here on the offenses where one is convicted, that, for example, if you say whether the applicant or directors have ever been convicted of which case, of which offense, I think we need to be clear. We need to be clear on this, on this clause, on the conviction and the offense. Thank you.
Good. So we have had 13.
Phrase clause 2, but the explanation was given, and then also the retention of clause 22 as is was made by the Attorney General. The Honorable Basalirwa has issues with the structure of the bill, and especially he's saying we've been silent on the severity of punishments, both custodial and the fines. The logic for the severity is deterrence, as is now. And if you are not going to offend, why do you fear the consequences? that was the spirit. That was the spirit. Then he says that he comments about what he says is the imprecision of the offenses. E.g. on page 10 and 11, he speaks about aspects to do with foreign policy, with interests of Uganda, and that the interests of Uganda are broad and elastic, and that also political activities on page 11, and by extension the application on page 12 of who. I think we need to be specific to the crux of the law. It revolves around section 2.2. If we could read it, maybe for emphasis, application of the law. And for emphasis, I would want to repeat it, that this act applies to an agent of a foreigner. And an agent of a foreigner per se is not unlawful, provided we go by the dictates of the law. You register, you do your things transparently. But if you are going to get inflows and do the things prohibited under 2, then you bring yourself within the ambit of the law. But for emphasis, I would want to read it. This act applies to an agent of a foreigner. 2, for avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platforms. And it goes on to elaborate, engages in the political activities in Uganda, that is an agent of a foreigner, to further the interests of a foreigner. B, solicits, collects, disburses or dispenses contributions, loans, money or other things of value for the purposes of financing or sponsoring political activities to further the interests of a foreigner. C, represents the interests of a foreigner, blah, blah, blah. So the crux, I want to mention that the crux of the sanctions is section 2 of the bill. He comments also on the broad aspect of clause 13. I want to concede and say we can do better on clause 13. It's very broad, and we shall be amenable to any views that the committee, the 2 committees provide in that respect. If we can size it down to make it more concise, clause 13, Landed Attorney General, because it touches on
a number of things, weaken, undermine, damage, and most of which I think are not at cross purposes. One of them can do what we want to achieve. So we leave that one to the committee. We shall be amenable to a more concise definition without losing the input we want to achieve regarding especially the aspect of economic sabotage, because it has to relate to that subtitle that we want to address. Registration of an agent, bill creating prohibitions. Registration avoids, I want to say that registration, I'm still on, I think, Honorable Wasaliro, because he mentioned, he submitted on many things. I think pardon? Can we maybe move and then we shall leave the committee to do its work? Can we maybe with the permission of the chair? On declaration, the Honorable Wasari was asking at what stage do you declare? Section 22. And he was saying that the process becomes onerous. It is not, because the other laws he quoted, especially the Anti-Money Laundering Act, is for illicit money. But this is about using foreign money to do the things prohibited under Section 2. And we think registration is important for purposes of accountability and transparency, so that if you offend the law, we can catch you. But also, you can declare at registration or at any other time, if I can be precise, for purposes of Section 22. Honorable Secretary says that we talk about foreign interference, but we don't talk about internal interference. I want to say, to clarify, that the crux of this law is about monies coming from abroad to interfere with our sovereignty here. That's why there is nothing to do with internal interference, which is dealt with other laws, by other laws.
In any case, if
Honorable Okirol.
Just a minute. If the Honorable Member for 20 thinks the internal disruptions are not well regulated, you try to disrupt and you see.
I want also to pick on the other things that were specific to me, like the Honorable Odu says we didn't consult. I think we are even here in response to consultation, especially by those, including those agencies that he says are from government. But also, in government, the way we work, many of these agencies are represented by ministries, and we consulted widely. Including those agencies he quotes, like that one of Bank of Uganda, which is represented by one of the ministries that is part of cabinet. But we did consult, although consultation can't be like counting hairs. You can't consult everyone, but you can reasonably reach all the concerns raised, and I'm glad that we are here as part of that
Minister, let me just
consultation.
Briefly, let me clarify. After the initial consultation, we sat here. I'm asking these last 3 days, after Bank of Uganda, after Uganda Human Rights Commission, after...
Even now we are consulting, Honorable Dolo.
That's not what I'm saying, sir. And I hope you, if you have no answer, you can say yes
No, I have an answer.
Yes.
When you
Okay,
say
let me
consultation,
say, did you go back to Bank of Uganda?
you won't dictate the form. You are here. Bank of Uganda came, gave its views, and we are here to respond. What better consultation do you want?
You can now apportion marks in your mind, whether you have 30% or 70%.
The bill, Honorable Nwagaba, you are a very senior lawyer, and I would want to refer you to the long title of the bill. An act to provide for the protection of the sovereignty of the people of Uganda.
Where do I find it in the contents of the bill?
Need I add more? To designate the department responsible for peace and security as the responsible entity for the registration and regulation of agents of foreigners, to provide for the protection of the sovereignty of Uganda, to provide for the registration of agents of foreigners, to regulate the funding and any other assistance to agents of foreigners and for related matters. So, Honorable Nwagaba, I want to allay your fears. This is for the protection of the sovereignty of the people of Uganda. I think I'll leave it here for now and ask the learned Attorney General to speak to some of the other aspects raised by members. Honorable AG.
Thank you very much. Really to the issues of drafting, because I think the Minister has addressed the policy issues. How does, you're saying that, Honorable Basari was saying that the law in essence is stopping political activities from influencing policy. No, I think what the law is saying, let the political parties, and you're right, to can also catch the NRM, you should not do it for the interest of a foreigner. So yes, you're right. If the law comes into place, it will also catch NRM if it tries to do this for the interest of a foreigner. Application exclusion, yes, Honorable Basalira, if you look at clause 2.4, I do not know if it is clear enough. It is saying, but if there is anything that we have left out, if it is faith-based organizations and activities that are connected with the mission of faith-based organization, they've been specifically excluded. So, but if it's not clear, we can clarify it more, but we are trying to say it as clearly as we can. The penal provisions are not imprecise. I've heard you, and we'll be pleased with the comments of the committee on how we can make them, since the committee has actually identified that they're imprecise. I think they can make them precise because we have made the thing. But I thank Honorable Chiwanuka Abdallah, who has assisted me with the drafting here on clause 13. An agent of a person who knowingly publishes false information or participates in any disruptive activity that weakens. So I thank you, and I would appreciate the input, because I think that makes it clearer, because disruptive activity is already defined in the law, so I know exactly what it is that I will do in order for me to get caught out. What rights do you get for being registered? For being registered, you can do everything else for the interest of a foreigner except these ones. For example, it may sound ridiculous and thingy, but it's actually serious, because if, for example, I got a person who wanted me to come and lobby for them a policy, for example, removal of taxes on something. So I'm an agent of a foreigner. So I go to the minister, tell the minister I'm an agent of a foreigner, and I go and start lobbying in parliament, everywhere, in government, in ministries. I'm an agent of a foreigner. And I go and I do this. I lobby properly, you get paid, move on. That's the benefit you get. However, right now as it is, if you're not registered as an agent of a foreigner, and you go around government agencies trying to change a policy, and it turns out that you are doing it for the benefit of that foreigner, then you commit an offense. I'm not going to comment anymore on the issue of anti-money laundering. I am very clear in my mind that this has nothing to do with money laundering. Money laundering is dealing with illicit trade, illicit money. This is dealing with even legitimate money being used for wrongful acts. Foreign interference, an internal interference. I think Honorable from Ntwetwe, the member, the chair has answered it. But you must remember that this law is more about the Ugandan, and maybe to just comment on what the Honorable Minister said. This law is telling the Ugandans, don't do these things, because here you're dealing with a foreigner who could use Ugandan proxies. But if you want to change the law to protection of the state, I think we can write another law as a private member for that purpose. And for now, we deal with this one. But I don't think the people can be sovereign if the state, because I don't know what's the state without the people. So if you say that protection of the state is the people. The people are the sovereigns. So maybe I think because we don't use the people of Uganda throughout the bill, maybe that could, but I think that as a thing. So Honorable Abdallah, I've already commented. Thank you very much. We have noted the clarification on clause 13. Clause 18, delete the fit and proper. Fit and proper, it wouldn't make any difference, but it's just a standard that we have started using in legislation to understand. So if you went out there and asked what is the meaning of fit and proper, I would not need it. It is legally defined. They tell you must not be bankrupt, you must not be a convict, you must be a person of good standing. This is defined. So for us,
16.2. You look at 16.2. It has the tenets of
the tenets of fit and proper. But like you said, if you think it makes the bill look better, we have no problem removing it because the tenets are clearly set out. But the definition of fit and proper is now universally understood and accepted. On the issue of the consultations, the ministers addressed that. Role of on the issue, whatever is done under the Act of Parliament, which has been given here, is already government policy. Because policy of government is the written document, the constitution and the laws. Because when you get the law, you reduce it into a policy. So if Parliament has written a law on anything, and it's already a policy of government. So you're right, it is not, you cannot say that Parliament has authorized someone to do something and then you say that is a foreign policy. No. The moment Parliament passes it, it becomes part of policy.
So do you now mind if, when amending this law, we remove anything to do with the government policy and restrict it to laws made by Parliament?
No.
Talk about so how do I find the policy?
I've defined it for you in the law.
Where do I find the policy?
In those many documents that I've laid out. In those many documents that the ministerial policy statements we are giving you here are policy. The laws.
I'm talking about a Ugandan in Karamoja, not a member of Parliament.
You see,
other than the law, which is you can easily find. How does one find a policy?
Honorable Nwagaba, we have said that this must be done knowingly. Knowingly, intentionally, we keep using these things. So if a person doesn't know of the existence of the policy, and he can show that he did not know, the only problem with these policies, you see, we tend to think these policies are actually just documents. They're actually actions we do ordinarily. Like, for example, you will find it difficult if you ask the Ugandan, where is the policy on driving on the keeping left? Because, no, that's exactly what I'm telling you. It is in the law.
I can't know policies of the Ugandan government, but knows of a foreigner to deal with. Because you know the law, you don't know the local, but you know the foreign. How can that even be possible?
Yeah, thank you. So for 8, the deletion of a person.
Honorable Kahonda, this is for you.
Honorable Kahonda, yes, you did comment. Yes, I did say earlier that we are removing a person throughout the bill and just leaving it as agent of a foreigner. So we take away anything. So yes, in 8.3 we skipped that. I apologize and thank you for pointing it out. ILO funds, Honorable Uwerike, these are of course excluded. they're excluded. If you look at 8, that's what I'm saying. The money received by trade unions. The what?
An express exclusion.
I think, honorable members of the committee, you can put everyone in here that you want to put here, so long as that person does not, even if a trade union went and started doing these activities in 2-2, they become an agent of a foreigner. So you can exclude them. Even lawyers, if they do these things, because if you tell me that you got money from your client to recruit rebels, but for you are a lawyer who is excluded from things, it's not acceptable. That is why we are saying concentrate on the purpose of the law. If I got my money for commercial business, I'm doing my commercial, it will not affect you at all. If you got the money for your family business, family use, it will not affect you at all. But colleagues, if any of us got money from a foreigner and did any of the things that are set out in 2.2, we commit the offense. All the functions of the department are under clause 4. You said that we need to think. So if you think we need to move that, but the functions are there. Clause 17, Honorable Oseku, yes, we can look at the ministerial discretion, but if you say the moment the recommendation is made, then the minister must give, then we may as well just ask the committee to issue. Because a recommendation must attract a decision, and that is the decision of the minister. Honorable Anna, no, I don't know. The definition of a foreigner cannot definitely include a Ugandan. And I want us to read it together. So because now I may have to put another for avoidance of doubt.
No, she was saying, sir, that we have now shifted. We have made it worse by making everybody culpable. But what I'm saying, yes, Honorable Adeke, is that being a Ugandan is not a shield from criminal liability if you offend. So you can't say I'm a Ugandan. If I commit murder, I'm scot-free. I go scot-free. No, so I think,
let me finish this, because you are saying we have defined the Ugandan as a foreigner. And I am telling you, no, she says a foreigner.
That we removed that.
Let me finish. We are defining a foreigner. It's at page 10. It says a foreigner means a person who engages, undertakes, controls, subsidizes an activity specified in clause 2.2 and includes a non-citizen, a foreign government, a corporation, and an international organization. We have specifically deleted a Ugandan citizen. We have specifically deleted any person, institution, or body. I think what you're saying is that a Ugandan can be an agent of a foreigner. And that's correct. And that one is correct. A Ugandan can be an agent of a foreigner. If I receive money to do something in the interest of a foreigner, I can be an agent of a foreigner. Honorable Zijan, if a Ugandan citizen receives money for political activities for an election, and can they be an agent of the foreigner? Yes. You, Honorable Zijan, receiving money from a foreigner for your campaign, for the purpose of working for the foreigner. If you go and work in Qatar and come back with your money.
I can clarify. A Ugandan, for purposes of promoting his political activities here, and it can be an individual or a political party or an agency, do they become agents of foreigners even though they are propagating their own interest of their politics?
No, because if they are propagating their own interest, they are not necessarily, but you need to read the law with body of laws. Because now you have to go to the PPOA. It has how you fund political parties. So you need to be careful there. Don't take my word and just go and do what you are doing. But if you are getting this money, if you see in 2.2 they are saying engaging in political activities in Uganda to further the interest of a foreigner. Solicits, collects funds, contributions, loans for purposes of financing or sponsoring political activities to further the interest of a foreigner. So that is where we are. So,
Attorney General, just help me, Attorney General, democratic dispensation. In Africa, there are multi-party. There is multi-party type of politics in African continent, and then assuming that sitting governments, have opposition, which actually intending to take power and have genuine friends outside this country. They do not intend to disrupt government policies or programs, but are getting friends from abroad with the intention of also taking power. How do you then categorize them as people who intend to disrupt government?
No, but you see, we are discussing laws. The first thing is we don't describe them. You don't become an agent of a foreigner by just me sitting down and looking at you and saying you're an agent of a foreigner. This has described for you the things that end up making you an agent of a foreigner. Now, for example, let me use an easier example. We have a law which says you shall not kill anyone, and if you kill anyone, you will become a murderer, and you will be convicted of murder. So the police comes, arrests you. You don't become a murderer. You're a suspect. So they take you through court, probable cause, prima facie case. When they convict you is when we call you a murderer. So it's when the court finds you to be an agent of a foreigner, because the government must bring the evidence that you're an agent of a foreigner and put this before you can be called an agent of. But this law is describing to you the things that you would do which would lead you to being defined as an agent of a foreigner.
Okay. If I'm not right, you can then be able to correct. That means, in my view, that money which comes from out of Uganda to support Honorable Wakoli in his campaign, but that money is just to support him in his campaign, not necessarily in the interest of that foreigner, but for his politics. That money is not subject to this bill.
No, it is saying if you're doing it for the interest of the foreigner, the only problem that we have here is we have this age-old saying, he who pays the piper calls the tune. But it is just an old adage. We don't know whether it is not always necessarily true. But what we are saying is that when you're reading this, you need to read it in consonance with the PPOA and other laws, because those govern the financing of political parties. And so, Honorable Chairs, for me, I think those are
my issue.
You deal with substantiality if you're going away from the object. Here, what the object is maintained, the 2.2 is maintained. In some places, we are just adding subject to 2.2 for avoidance of doubt. So we had an interpretation, like for example, the interpretation of whether money from Ugandans in the diaspora would be subject to this law. When I came here, I told you no, the interpretation of this law doesn't mean that. But after hearing it, we said, what is the point? Let us just put for avoidance of doubt. This is what it is. So I don't think it substantially changes. I've missed a question that Honorable Namboze. Some of the questions I think were addressed to you, whether it would be appropriate to reopen to the public. That's for the committee to decide. I brought a bill. What else will I change? Honorable Namboze, for me, in my line of work, flexibility in changing thoughts is actually a good thing, because I like to learn new things. So if you give me advice and you think that something may cause a problem, even after I leave now and I go back and read this thing and someone comes and says, by the way, when you read this clause, it may have this meaning. I do not have the monopoly of this knowledge, so I benefit from that information. So I could come back to you to change something.
Why I raised it, Mr. Attorney General?
I know why you raised it.
Yes. And
Yeah, I know
want
why you
you to
raised
address
it.
that.
The why you raised it is, should we because you're saying we might.
What I was trying to say is that haven't we limited ourselves to rush through this act? That maybe you would bring a better bill given more time.
Yeah, actually, if you gave me 2 years, the circumstances will be different. I'll probably bring you a different thing. Whether it's better is one thing, different is another. Because this law 2 years ago would not have been here. Necessary. 10 years ago would not have been necessary. So time, the law that we are writing now is for the circumstances that obtain now.
Mr. Attorney General, I'm of the opinion, tell me if I'm wrong, I'm of the opinion that we have rushed this bill. And that is why when people come, we did not consult those we had to consult. That's why we are now picking thoughts from people who have been able to appear before the committee. Maybe if we had given ourselves some more time and consulted all the stakeholders, we would come up with a law that is agreeable, not controversial, but that we would legislate for Uganda, not necessarily like as if we are fighting each other. Everybody who came here, apart from one person, was against the bill, including people from government departments.
Yeah, so I think you have. I cannot disagree with your opinion. That is your opinion, and I cannot really fight with it.
AG also on page 13 on the issue.
The fines, yes, we are looking at this as deterrent fines, right? But when you look at the fines, we have both custodial and a fine. Custodial, we are looking at about 20 years. When we look at a fine, if you convert the currency points, it takes us to about 2 billion. Usually, if we have the alternative of a fine, it's like a leeway for one to realize that, yes, I think I've made a mistake under the circumstances, but court tells you pay this fine and get back to reintegrate it to the community. But if you look at the harshness with which we have our fine of 2 billion shillings in our Uganda, I think it will become a bit very more deterrent and even custodial. Then lastly, on the issue of 2.2, we have on several paragraphs used the word solicit. AG, when you go to solicit, sometimes you don't know whether you get or you will not what? Get. So, yes. You may be successful or unsuccessful.
You said you
so
just declare.
I don't know what we are soliciting. Can we do away with that word soliciting and we use others?
Actually, that's where the problem starts. I rest my case, Honorable Chair.
Order.
Those words of Honorable Oyuelo may be attributed to me.
AJ, I don't know whether you are part of the words.
Okay. No, but I think the soliciting has you have already conceptualized. The mens rea is in place. You have started the process, and you're just failing to get through.
And lastly, the AG had, I speak to the